Question 1. Comparative studies suggest that a driver applicant in Ontario, Canada, who has just passed their G1 knowledge test, needs to understand the specific limitations of their current licensing stage. Which of the following best reflects the necessary explanation to ensure the applicant is fully aware of their immediate legal and safety obligations? Option A. Provide a general overview of common driving rules applicable to all license classes in Ontario. Option B. Briefly mention that there are some rules to follow but do not elaborate on the specific prohibitions of the G1 license. Option C. Clearly explain the specific conditions and limitations of the Ontario G1 license, including the requirement for a fully licensed supervising driver, the midnight to 5 a.m. driving prohibition, and the passenger restrictions. Option D. Assume the applicant has a sufficient understanding of G1 restrictions due to passing the knowledge test and focus on preparing for the G2 road test. Correct answer is C. Clearly explain the specific conditions and limitations of the Ontario G1 license, including the requirement for a fully licensed supervising driver, the midnight to 5 a.m. driving prohibition, and the passenger restrictions. Explanation. Scenario analysis. This scenario presents a professional challenge for a driver applying for a license in Ontario, Canada, concerning their understanding of the graduated licensing system. Challenge lies in ensuring the applicant comprehends the specific restrictions and requirements of their current license stage, which directly impacts road safety and legal compliance. Misunderstanding these rules can lead to serious consequences, including fines, license suspension, and increased accident risk. Careful judgment is required to assess not just the applicant's driving skill, but also their theoretical knowledge of the rules governing their driving privileges. Correct approach analysis. The best professional practice involves clearly and accurately explaining the specific conditions and limitations of the applicant's current Ontario G1 license. This includes detailing the requirement for a fully licensed supervising driver, the prohibition of driving between midnight and 5 a.m., and the restriction on carrying passengers other than a supervising driver or immediate family members. This approach is correct because it directly addresses the applicant's knowledge gap regarding the Ontario Highway Traffic Act and its regulations pertaining to graduated licensing. Adherence to these specific provincial rules is paramount for legal operation of a vehicle and for ensuring the safety of the applicant and the public. Incorrect approach is analysis. One incorrect approach would be to provide a generic overview of driving rules without emphasizing the specific restrictions of the G1 license. This fails to address the applicant's immediate legal and safety obligations under the Ontario graduated licensing system, potentially leaving them unaware of critical prohibitions. Another incorrect approach would be to assume the applicant understands the rules simply because they have passed a basic knowledge test. This overlooks the practical application and specific nuances of the G1 stage, which are crucial for safe and legal driving. Further incorrect approach would be to focus solely on the upcoming G2 road test without reinforcing the current G1 restrictions. While preparing for the next stage is important, neglecting to ensure understanding of current rules is a significant oversight that compromises immediate safety and compliance. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes clear, specific, and relevant information. This involves 1. Identifying the applicant's current licensing stage and its associated regulations, in this case, the Ontario G1 license. 2. Directly addressing and explaining all specific restrictions and requirements of that stage. 3. Verifying the applicant's comprehension of these rules. 4. Linking this knowledge to the principles of road safety and legal compliance within the specified jurisdiction. Question 2. The investigation demonstrates that a financial advisor in Ontario, Canada, has a client who has consistently expressed a low risk tolerance and a preference for capital preservation. During a recent meeting, the client, without any apparent change in their financial circumstances or stated goals, suddenly expresses a strong desire to invest a significant portion of their portfolio in a highly speculative cryptocurrency fund. What is the most appropriate course of action for the advisor? Option A. Engage in a detailed discussion with the client to understand the reasons behind this sudden interest. Explain the risks associated with the speculative investment in relation to their stated objectives and risk tolerance, and if the client's objectives have genuinely changed, ensure any recommendation aligns with their updated profile and is thoroughly documented. Option B. Proceed with the investment but make a note in the client's file that the client insisted on the investment despite the advisor's reservations. Option C. Politely decline the client's request, informing them that the investment is not suitable given their previously established conservative investment profile. Option D. Immediately execute the client's requested investment in the cryptocurrency fund, as the client is ultimately responsible for their investment decisions. The correct answer is A. Engage in a detailed discussion with the client to understand the reasons behind this sudden interest. Explain the risks associated with the speculative investment in relation to their stated objectives and risk tolerance. And if the client's objectives have genuinely changed, ensure any recommendation aligns with their updated profile and is thoroughly documented. Explanation. The investigation demonstrates a scenario where a financial advisor in Ontario, Canada, is presented with a client's request that appears to conflict with their stated investment objectives and risk tolerance. This situation is professionally challenging because it requires the advisor to balance client autonomy with their fiduciary duty to act in the client's best interest and adhere to regulatory requirements. Misjudging the situation could lead to unsuitable recommendations, potential client harm, and regulatory sanctions. The correct approach involves a thorough, documented discussion with the client to understand the underlying reasons for their sudden interest in a high-risk, speculative investment, despite their previously established conservative profile. This approach prioritizes understanding the client's current motivations, educating them on the risks involved, and assessing whether their stated objectives have genuinely changed or if this is a fleeting impulse. If the client's objectives have indeed changed, the advisor must then ensure any recommended investment aligns with these new objectives and their updated risk tolerance, all while maintaining comprehensive documentation of the entire process. This aligns with the Ontario Securities Commission, OSC, Rule 31-505, which mandates that registrants must deal fairly, honestly, and in good faith with clients, and understand their needs and objectives. Furthermore, the advisor's duty of care requires them to ensure suitability of investments, which necessitates a deep understanding of the client's circumstances. An incorrect approach would be to immediately proceed with the client's request without further inquiry. This fails to uphold the advisor's fiduciary duty to ensure suitability and act in the client's best interest. Bypasses the critical step of understanding the client's motivations and assessing the appropriateness of the investment given their established profile, potentially exposing the client to undue risk. Another incorrect approach would be to dismiss the client's request outright due to their previously stated conservative profile, without engaging in a dialogue to understand any potential shift in their circumstances or risk appetite. This demonstrates a lack of flexibility and a failure to adequately serve the client's evolving needs, potentially alienating the client and failing to provide appropriate guidance. A further incorrect approach would be to proceed with the recommendation, but fail to document the conversation and the rationale behind the decision. This omission leaves the advisor vulnerable in the event of a complaint or regulatory review, as there is no evidence to support that the client's best interests were considered and that the recommendation was suitable. The professional reasoning process in such situations should involve a structured approach. First, actively listen to and understand the client's request. Second, critically assess the request against the client's known profile, objectives, and risk tolerance. Third, engage in open and honest communication with the client, seeking clarification and providing education on risks and suitability. Fourth, if the client's intentions are confirmed and the investment is deemed suitable for their updated profile, proceed with appropriate documentation. If not, clearly explain why the request cannot be accommodated and explore alternative solutions that align with their best interests and regulatory requirements. Question 3. Assessment of a learner driver's ability to navigate a busy, multi-lane intersection in Toronto, Ontario. During their G2 road test, a driving instructor observes the learner hesitating significantly at the yield line, causing a backlog of traffic and exhibiting signs of confusion regarding the right-of-way. What is the most appropriate immediate action for the instructor to take to ensure safety and uphold the standards of the Ontario Ministry of Transportation? Option A. Immediately stop the vehicle on the approach to the intersection to avoid any further complications. Option B. Verbally instruct the learner to stop once they have already entered the intersection. Option C. Apply the secondary brake to safely stop the vehicle before entering the intersection, preventing a potentially dangerous maneuver. Option D. Allow the learner to proceed through the intersection despite the hesitation, making a note of the error for post-test discussion. The correct answer is C. Apply the secondary brake to safely stop the vehicle before entering the intersection, preventing a potentially dangerous maneuver. Explanation: scenario analysis. This scenario presents a professional challenge for a driving instructor in Ontario, Canada, as they must balance the immediate need to assess a learner-driver's ability to navigate a complex intersection with the paramount importance of road safety and adherence to the Ontario Ministry of Transportation's MTO licensing requirements. The instructor must make a judgment call that prioritizes the learner's safety and the safety of other road users, while also ensuring the assessment accurately reflects the learner's readiness for independent driving. Correct approach analysis. The best professional practice involves the instructor taking immediate, decisive action to ensure safety. This means intervening by applying the secondary brake if the learner-driver is exhibiting dangerous behavior, such as failing to yield appropriately or entering the intersection unsafely, thereby preventing a potential collision. This approach is correct because it directly addresses the immediate safety risk, aligning with the MTO's emphasis on safe driving practices and the instructor's ethical duty of care to both the learner and the public. The MTO's driver's handbook and the curriculum for driving instructors stress the importance of proactive intervention to prevent accidents. Incorrect approaches analysis. One incorrect approach involves allowing the learner to proceed through the intersection despite the clear danger, with the intention of noting the error later. This is professionally unacceptable as it disregards the immediate safety risk and potentially endangers the learner, other drivers, and pedestrians. It violates the instructor's duty of care and the MTO's mandate to ensure drivers are competent and safe before licensing. Another incorrect approach is to immediately stop the vehicle on the approach to the intersection. While seemingly cautious, this action can be disruptive and may not accurately assess the learner's ability to handle the specific challenge of navigating the intersection itself. Furthermore, stopping abruptly in traffic can create its own safety hazards and does not demonstrate the instructor's ability to guide the learner through a complex situation. A further incorrect approach is to verbally instruct the learner to stop once they are already within the intersection. This is too late to prevent a potential collision if the learner has already made a critical error in judgment. The intervention needs to be timely and effective, and a verbal command at this stage is unlikely to be sufficient to avert danger. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes safety above all else. This involves continuous observation and assessment of the learner's actions, anticipating potential hazards, and being prepared to intervene decisively and effectively when a safety risk is identified. The intervention should be proportionate to the risk and aimed at preventing harm while still allowing for a meaningful assessment of the learner's skills where possible. The ultimate goal is to ensure that only safe and competent drivers are licensed, as mandated by the MTO. Question 4. Compliance review shows that a driver operating a vehicle in Ontario experiences a sudden and complete failure of their brake lights while driving on Highway 401 during moderate evening traffic. The driver is concerned about being late for an important appointment. What is the most appropriate course of action? Option A. Pull over to the side of the road and attempt to fix the brake light yourself while traffic continues to pass. Option B. Attempt to signal turns manually and drive cautiously, hoping to reach the destination without incident. Option C. Safely pull over to the shoulder of the highway as soon as it is safe to do so, turn on hazard lights, and contact roadside assistance or the police to report the vehicle defect. Option D. Continue driving to the nearest mechanic, as the appointment is time-sensitive and the vehicle can still be driven. The correct answer is C. Safely pull over to the shoulder of the highway as soon as it is safe to do so, turn on hazard lights, and contact roadside assistance or the police to report the vehicle defect. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a driver to balance the immediate need to complete a driving task with the overarching responsibility to adhere to traffic laws and ensure public safety. The driver's personal urgency, while understandable, must not override their legal and ethical obligations on the road. Careful judgment is required to prioritize safety and compliance over personal convenience. Correct approach analysis. The best professional practice involves immediately ceasing the operation of the vehicle in a safe manner and contacting the appropriate authorities to report the issue. This approach is correct because it prioritizes public safety and legal compliance above all else. In Ontario, the Highway Traffic Act mandates that drivers operate vehicles in a safe and controlled manner. A malfunctioning brake light is a significant safety defect that impairs the vehicle's visibility to other road users, particularly at night or in adverse weather conditions, and directly contravenes the requirement to operate a vehicle safely. Reporting the issue to the authorities, such as the police or a roadside assistance service, ensures that the vehicle is either repaired or removed from the road, preventing potential accidents and further legal infractions. This aligns with the ethical responsibility of all road users to contribute to a safe driving environment. Incorrect approaches analysis. Continuing to drive with a known brake light malfunction is a direct violation of the Highway Traffic Act's provisions regarding vehicle safety and operation. This action creates an immediate hazard for other drivers, increasing the risk of rear-end collisions. Furthermore, it demonstrates a disregard for the law and the safety of others. Attempting to fix the brake light while driving is extremely dangerous and illegal, as it distracts the driver and takes their attention away from operating the vehicle safely. This is a clear breach of the duty of care owed to other road users. Driving to the nearest mechanic without first reporting the issue to authorities could still lead to being stopped by law enforcement and cited for operating an unsafe vehicle, and it delays the necessary corrective action, prolonging the safety risk. Professional reasoning. Professionals in any field, including driving, must employ a decision-making framework that prioritizes safety, legality, and ethical conduct. When faced with a situation where a vehicle's safety is compromised, the immediate steps should be to mitigate risk. This involves stopping the vehicle safely, assessing the situation, and taking appropriate action to rectify the problem or seek assistance from authorized personnel. Personal urgency should never supersede these fundamental responsibilities. Question 5. Regulatory review indicates that an investment advisor in Ontario has a client who, despite having a low risk tolerance and a short-term investment horizon, is insistent on investing a significant portion of their portfolio in a highly speculative, illiquid private equity fund. The advisor has explained the inherent risks and the mismatch with the client's stated profile. What is the most appropriate course of action for the advisor to take? In accordance with Ontario Securities Commission (OSC) regulations, Option A. Proceed with the client's preferred investment in the private equity fund, documenting the client's insistence to protect against future liability. Option B. Politely refuse to discuss the private equity fund further, stating that it is not an investment the firm offers. Option C. Clearly explain to the client the risks and potential downsides of the speculative investment, referencing the suitability requirements under OSC Rule 31-103, and propose alternative investments that align with the client's stated risk tolerance and investment horizon. Option D. Advise the client to seek independent financial advice before proceeding with the private equity investment, without offering any alternative suggestions. Correct answer is C. Clearly explain to the client the risks and potential downsides of the speculative investment, referencing the suitability requirements under OSC Rule 31-103, and propose alternative investments that align with the client's stated risk tolerance and investment horizon. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated preference and the advisor's fiduciary duty to act in the client's best interest, particularly when that preference might lead to suboptimal outcomes or increased risk. The advisor must navigate this by prioritizing regulatory compliance and ethical obligations over simply acceding to client demands. Careful judgment is required to balance client autonomy with the advisor's responsibility to provide sound, regulated advice. Correct approach analysis. The best professional practice involves clearly explaining to the client the risks and potential downsides of their preferred investment strategy, specifically referencing the limitations and suitability requirements outlined in the Ontario Securities Commission (OSC) regulations regarding Know Your Client (KIC) and suitability. This approach involves educating the client on why their chosen investment might not align with their stated financial goals, risk tolerance, or investment horizon, as mandated by OSC Rule 31-103. The advisor then offers alternative, suitable investments that meet the client's objectives while adhering to regulatory standards. This upholds the advisor's fiduciary duty and ensures compliance with the OSC's stringent suitability requirements. Incorrect approaches analysis. One incorrect approach involves proceeding with the client's preferred investment without adequate disclosure or consideration of suitability. This directly violates OSC Rule 31-103, which mandates that advisors must take reasonable steps to ensure that any recommendation or decision to trade is suitable for the client. Failing to address the mismatch between the client's stated needs and the investment's characteristics is a significant regulatory and ethical failure. Another incorrect approach is to dismiss the client's preference outright without a thorough discussion or explanation. While the advisor has a duty to ensure suitability, alienating the client by refusing to engage with their ideas can lead to a breakdown in the advisor-client relationship and may not ultimately serve the client's best interests. This approach fails to meet the spirit of client-centric advice, even if the underlying intention is to protect the client. A third incorrect approach is to document the client's insistence on the unsuitable investment as a way to absolve oneself of responsibility, without first making a genuine effort to explain the risks and offer suitable alternatives. While documentation is important, it cannot replace the proactive duty to advise and ensure suitability as required by the OSC. This is a superficial compliance measure that fails to address the core ethical and regulatory obligation. Professional reasoning. Professionals should employ a structured decision-making process that prioritizes regulatory compliance and ethical conduct. This involves 1. Thoroughly understanding the client's financial situation, objectives, and risk tolerance kick. 2. Evaluating the suitability of any proposed investment against these parameters, referencing relevant provincial regulations e.g. OSC Rule 31-103. 3. Clearly and transparently communicating the rationale behind recommendations, including potential risks and benefits, and explaining why certain investments may not be suitable. 4. Documenting all discussions and decisions, ensuring that the client's best interests, as defined by regulatory standards, are paramount. If a client insists on an unsuitable course of action, the advisor must exhaust all reasonable efforts to educate and dissuade them, and if necessary, consider whether continuing the professional relationship is appropriate. Question 6. Consider a scenario where, during a supervised driving practice session on a residential street in Toronto, Ontario, a student driver repeatedly fails to check their blind spot before changing lanes, despite clear verbal instructions from their instructor. What is the most appropriate course of action for the driving instructor? Option A. Ignore the repeated failure to check the blind spot, as it is a minor oversight on a quiet street, and proceed with the rest of the lesson to ensure all planned objectives are met. Option B. Continue the lesson, assuming the student will eventually remember to check their blind spot as they gain more experience and focus on completing the planned route. Option C. Immediately pull over to a safe location, stop the vehicle, and provide direct feedback to the student about the critical importance of blind spot checks, explaining the risks and potentially pausing the lesson until the student demonstrates understanding and compliance. Option D. Immediately end the lesson, drive the student home, and file a formal complaint with the Ontario Ministry of Transportation regarding the student's unsafe driving. The correct answer is C. Immediately pull over to a safe location, stop the vehicle, and provide direct feedback to the student about the critical importance of blind spot checks, explaining the risks and potentially pausing the lesson until the student demonstrates understanding and compliance. Explanation. Scenario analysis. This scenario presents a professional challenge for a driver instructor in Ontario, Canada, concerning the ethical and legal implications of a student's driving behavior during a practice session. The instructor must balance the immediate need to ensure public safety with the student's learning process and the regulatory requirements for driver training in Ontario. The instructor's judgment is critical to prevent potential accidents and uphold the standards set by the Ontario Ministry of Transportation. Correct approach analysis. The best professional practice involves immediately intervening to ensure safety. This means stopping the vehicle in a safe location and addressing the observed dangerous behavior directly with the student. This approach aligns with the fundamental duty of care owed by a driving instructor to their student and the public, as mandated by the Ontario Highway Traffic Act and the ethical guidelines for driving instructors. The instructor must prioritize preventing harm and reinforcing safe driving habits, which includes ceasing the practice session if unsafe behavior persists and explaining the reasons clearly to the student. This proactive intervention is crucial for both immediate safety and the student's long-term development as a responsible driver. Incorrect approaches analysis. One incorrect approach is to continue the lesson, assuming the student will correct their behavior without intervention. This fails to uphold the instructor's duty of care and disregards the immediate risk posed by the dangerous driving. It could be seen as negligence under the Ontario Highway Traffic Act, as the instructor has a responsibility to actively guide and correct unsafe practices. Another incorrect approach is to abruptly end the lesson without explanation and report the student to the authorities immediately. A reporting may be necessary in severe cases. A lack of immediate feedback and explanation to the student undermines the educational aspect of the instructor's role. The primary goal is to teach and improve driving skills, and a complete lack of communication hinders this objective. A further incorrect approach is to dismiss the behavior as minor and focus solely on completing the planned lesson objectives. This demonstrates a lack of professional judgment and a failure to recognize potentially escalating unsafe habits. The instructor's role is to identify and address all forms of dangerous driving, not just those that immediately threaten safety, to foster a comprehensive understanding of responsible driving. Professional reasoning. Professionals in this situation should employ a risk assessment and intervention framework. First, assess the immediate danger posed by the student's action. If a risk to safety is identified, the priority is to mitigate that risk through immediate safe intervention. Second, communicate clearly and constructively with the student, explaining the observed behavior, its potential consequences, and the expected corrective actions. Third, document the incident and the intervention. Finally, consider further steps based on the severity of the behavior and the student's response, which may include recommending additional training or, in extreme cases, reporting to the relevant authorities. Question 7. Upon reviewing a client's profile in Ontario, Canada, a financial advisor notes that the client has explicitly stated a strong preference for investments with the potential for very high returns, even if it means accepting significant risk. However, a preliminary review of the client's financial statements reveals a modest income, limited savings, and substantial outstanding debts. What is the most appropriate course of action for the advisor to take regarding investment recommendations? Option A. Conduct a thorough assessment of the client's overall financial situation, including income, assets, liabilities, investment objectives, and time horizon, to determine the true suitability of high-return investments, and discuss the findings and potential risks openly with the client. Option B. Advise the client that their current financial situation is not conducive to pursuing high-return investments and suggest they focus solely on debt reduction and building an emergency fund before considering any investment. Option C. Recommend a diversified portfolio that includes a mix of conservative and moderate-risk investments, explaining to the client that this approach balances their desire for growth with a more prudent management of their current financial constraints. Option D. Proceed with recommending a portfolio heavily weighted towards high-risk, high-return investments, as this aligns with the client's stated preference, and document the client's explicit instruction. Correct answer is A. Conduct a thorough assessment of the client's overall financial situation, including income, assets, liabilities, investment objectives, and time horizon, to determine the true suitability of high-return investments and discuss the findings and potential risks openly with the client. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, who is tasked with advising a client on investment suitability. The challenge lies in balancing the client's stated risk tolerance with their actual financial situation and the advisor's professional obligations under Ontario securities law and the Investment Industry Regulatory Organization of Canada (IIROC) rules. A failure to conduct thorough due diligence can lead to unsuitable recommendations, client harm, and regulatory sanctions. Careful judgment is required to ensure that recommendations are not only aligned with stated preferences, but also with the client's capacity to bear risk and their overall financial objectives. Correct approach analysis. The best professional practice involves a comprehensive assessment of the client's financial situation, investment knowledge, and experience, in addition to their stated risk tolerance. This approach, which involves gathering detailed information about the client's income, assets, liabilities, investment objectives, and time horizon, is mandated by regulatory requirements in Ontario, such as those outlined by the Ontario Securities Commission (OSC) and EROC. Specifically, advisors have a duty to know their client kick and to ensure that any investment recommendation is suitable for the client's circumstances. This holistic review ensures that the advisor can make an informed judgment about the client's true capacity for risk and the appropriateness of specific investments, thereby fulfilling their fiduciary and regulatory obligations. Incorrect approach is analysis, recommending investments solely based on a client's stated preference for high returns without a thorough assessment of their financial capacity to absorb potential losses, is a significant regulatory and ethical failure. This approach ignores the fundamental principle of suitability, which requires advisors to consider the client's entire financial picture. Another incorrect approach involves prioritizing the client's desire for quick profits over a prudent investment strategy, as this can lead to recommendations that are overly speculative and expose the client to unacceptable levels of risk, violating the duty of care. Furthermore, relying on a client's self-assessment of their risk tolerance without independent verification or deeper probing can be misleading, as individuals may overestimate their comfort with risk when not faced with actual market volatility. This can result in recommendations that are not truly suitable, leading to potential client dissatisfaction and regulatory scrutiny. Professional reasoning. Professionals should adopt a structured decision-making process that begins with a comprehensive client discovery phase. This phase must go beyond surface-level inquiries to uncover the client's true financial situation, investment objectives, and capacity for risk. Advisors should then cross-reference stated preferences with objective financial data and regulatory guidelines. When there is a discrepancy, further discussion and clarification are essential. The ultimate decision should always prioritize the client's best interests and adhere strictly to regulatory requirements for suitability and know your client kick principles. Question 8. When evaluating the implementation of a client's investment strategy in Ontario, Canada, what is the most professionally responsible approach for a financial advisor to take regarding the selection of trading platforms and execution methods? Option A. Implement the strategy using the most sophisticated and technologically advanced trading platform available, regardless of the associated costs or the client's portfolio size. Option B. Conduct a comprehensive review of available trading platforms and execution methods, prioritizing those that offer the best combination of cost-effectiveness, efficiency, and compliance with Ontario Securities Commission regulations, ensuring the chosen method aligns with the client's best interests and is thoroughly documented. Option C. Proceed with the implementation using the first available platform that can execute the trades, without conducting a detailed cost-benefit analysis or considering specific client needs beyond the basic investment instructions. Option D. Select the trading platform and execution method that is most familiar and convenient for the advisor and their firm, assuming it meets basic regulatory requirements. The correct answer is B. Conduct a comprehensive review of available trading platforms and execution methods, prioritizing those that offer the best combination of cost-effectiveness, efficiency, and compliance with Ontario Securities Commission regulations, ensuring the chosen method aligns with the client's best interests and is thoroughly documented. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, who is tasked with implementing a client's investment strategy. The challenge lies in balancing the client's stated preferences with the advisor's fiduciary duty and the regulatory requirements of the Ontario Securities Commission (OSC). The advisor must ensure that the chosen implementation method aligns with the client's best interests, considering factors like cost, efficiency, and suitability, while adhering to the OSC's rules on fair dealing and suitability. The advisor's judgment is critical in navigating potential conflicts of interest and ensuring transparency. Correct approach analysis. The best professional practice involves a thorough assessment of the client's financial situation, investment objectives, and risk tolerance, followed by the selection of implementation methods that are most cost-effective and efficient for the client, while also being compliant with OSC regulations. This approach prioritizes the client's best interests by seeking the most advantageous execution for their investments, considering factors such as trading costs, market impact, and the availability of suitable investment products. The advisor must document this process meticulously, demonstrating how the chosen implementation aligns with the client's profile and regulatory obligation. particularly the duty to act in the client's best interest, as mandated by Ontario securities law. Incorrect approach is analysis. One incorrect approach involves prioritizing the advisor's firm's preferred brokerage or trading platform solely based on internal incentives or ease of use, without a rigorous comparison of costs and benefits for the client. This fails to uphold the duty to act in the client's best interest and may violate OSC rules regarding fair dealing and avoiding conflicts of interest. Another incorrect approach is to implement the strategy using a method that is overly complex or expensive for the client's portfolio size, even if it is technically feasible. This demonstrates a lack of consideration for the client's financial capacity and could lead to unnecessary erosion of investment returns, contravening the principle of suitability and the advisor's obligation to provide advice that is appropriate for the client. A further incorrect approach is to proceed with implementation without adequately documenting the rationale behind the chosen methods and the due diligence performed. This lack of documentation makes it impossible to demonstrate compliance with regulatory requirements and leaves both the client and the advisor vulnerable in case of future disputes or regulatory review. Professional reasoning. Professionals should adopt a client-centric decision-making framework. This involves first understanding the client's needs and objectives comprehensively. Then, they must identify all available implementation options and objectively evaluate them against criteria such as cost, efficiency, suitability, and regulatory compliance. The chosen method must be demonstrably in the client's best interest and fully compliant with all applicable regulations, such as those set forth by the OSC. Transparency and thorough documentation are paramount throughout the process. Question 9. The analysis reveals that an applicant presents a valid driver's license from another Canadian province for a motorcycle endorsement at an Ontario Ministry of Transportation licensing office. The applicant's provincial license is for a standard automobile class, but does not explicitly list a motorcycle endorsement. The applicant verbally states they have extensive motorcycle riding experience and possess a separate, expired motorcycle license from their home province. What is the most appropriate course of action for the licensing agent to ensure compliance with Ontario's graduated licensing system for motorcycle endorsements? Option A. Deny the motorcycle endorsement immediately, citing the absence of an explicit motorcycle class on the current provincial license, without exploring alternative documentation or testing options. Option B. Issue the motorcycle endorsement based on the applicant's current provincial driver's license and their verbal confirmation of riding experience, assuming interprovincial recognition of equivalent experience. Option C. Request the applicant provide proof of their prior, expired motorcycle license and any other documentation required by Ontario's Highway Traffic Act and its associated regulations to establish eligibility for a motorcycle endorsement, and if necessary, direct them to the appropriate testing procedures. Option D. Accept the applicant's expired motorcycle license as sufficient proof of experience and proceed with issuing the endorsement, bypassing any further verification or testing requirements. The correct answer is C. Request the applicant provide proof of their prior, expired motorcycle license and any other documentation required by Ontario's Highway Traffic Act and its associated regulations to establish eligibility for a motorcycle endorsement, and if necessary, direct them to the appropriate testing procedures. Explanation. The analysis reveals a common implementation challenge in the Ontario Ministry of Transportation's driver licensing process, specifically concerning the interpretation and application of the Graduated Licensing System, GLS, for motorcycle endorsements. The scenario is professionally challenging because it requires a licensing agent to balance the strict adherence to regulatory requirements with the practical realities of applicant documentation and the potential for administrative error. The agent must exercise careful judgment to ensure compliance with the Ontario Highway Traffic Act and its associated regulations, particularly regarding the proof of age and identity for applicants seeking a motorcycle license, while also avoiding undue burden on the applicant. The correct approach involves meticulously verifying the applicant's documentation against the requirements outlined in Ontario's Highway Traffic Act, specifically Regulation 596, which details the licensing process and acceptable forms of identification for various license classes, including motorcycle endorsements. This approach is correct because it prioritizes regulatory compliance ensuring that only eligible individuals are granted licenses, thereby upholding public safety and the integrity of the licensing system. The agent must confirm that the applicant has met all prerequisites for a motorcycle license, including any specific requirements related to their age and prior licensing history, as stipulated by Ontario law. An incorrect approach would be to accept a driver's license from another Canadian province that does not explicitly list a motorcycle class, assuming it automatically confers eligibility for an Ontario motorcycle endorsement. This is incorrect because Ontario's Highway Traffic Act and its regulations are specific to the province, and interprovincial recognition of endorsements is governed by specific agreements and the details of the issuing province's licensing framework. Simply assuming equivalence without verification is a regulatory failure. Another incorrect approach would be to proceed with issuing the motorcycle endorsement based solely on the applicant's verbal assurance that they have prior motorcycle riding experience, without requiring the necessary documentation or a practical skills test as mandated by Ontario's GLS for motorcycle licenses. This bypasses crucial safety checks and regulatory requirements designed to ensure competency. Finally, an incorrect approach would be to deny the motorcycle endorsement outright due to a minor discrepancy in the applicant's proof of address, without offering the applicant a reasonable opportunity to provide alternative, acceptable documentation as per the ministry's guidelines. While accuracy is paramount, an overly rigid interpretation that prevents a compliant applicant from rectifying a minor administrative issue can lead to an inefficient and frustrating process, and may not align with the spirit of service delivery within the regulatory framework. Professionals should employ a decision-making framework that begins with a thorough understanding of the relevant legislation and regulations, in this case, the Ontario Highway Traffic Act and its regulations. They should then assess the applicant's presented documentation against these requirements, identifying any gaps or ambiguities. If a discrepancy exists, the professional should consult internal guidelines or supervisors for clarification, and where permissible, offer the applicant clear instructions on how to rectify the issue. The ultimate goal is to achieve full compliance while facilitating the licensing process efficiently and fairly. Question 10. The risk matrix shows a potential for significant financial loss due to an upcoming regulatory change impacting vehicle emission standards in Ontario, effective in 18 months. Your current vehicle is estimated to require $2,500 in retrofitting to meet the new standards, or you could sell it now for $8,000 and purchase a compliant used vehicle for $15,000. Alternatively, you could wait 18 months, at which point your current vehicle's resale value is projected to drop to $5,000, and the cost of a compliant used vehicle is projected to increase to $17,000. If you choose to wait, you will incur an additional $300 per month in operating costs due to the old standards becoming less efficient. Calculate the total financial impact of waiting 18 months versus retrofitting immediately. Option A. Waiting 18 months results in a net financial disadvantage of $6,900 compared to retrofitting immediately. Option B. Waiting 18 months results in a net financial disadvantage of $3,900 compared to retrofitting immediately. Option C. Waiting 18 months results in a net financial advantage of $100 compared to retrofitting immediately. Option D. Waiting 18 months results in a net financial disadvantage of $5,000 compared to retrofitting immediately. Correct answer is A. Waiting 18 months results in a net financial disadvantage of $6,900 compared to retrofitting immediately. Explanation. The risk matrix shows a potential for significant financial loss due to an upcoming regulatory change impacting vehicle emission standards in Ontario. This scenario is professionally challenging because it requires a precise calculation of financial exposure under uncertainty, balancing potential gains against potential losses, and making a timely decision with incomplete information. The driver's ability to accurately assess and mitigate this risk directly impacts their financial well-being and compliance with future regulations. The correct approach involves a detailed calculation of the potential financial impact of the new emission standards on the driver's current vehicle and potential replacement vehicles. This includes estimating the cost of compliance, e.g., retrofitting, purchasing a new vehicle, versus the cost of noncompliance, e.g., fines, restricted usage. This approach is correct because it directly addresses the financial implications of the regulatory change, allowing for an informed decision based on quantitative analysis. Ontario's Highway Traffic Act and associated environmental regulations implicitly require drivers to operate vehicles in compliance with current standards, and proactive financial planning to meet future standards is a prudent measure to avoid penalties and maintain operational capability. An incorrect approach would be to ignore the upcoming regulatory change, assuming it will not significantly impact their current vehicle or that the costs will be negligible. This is professionally unacceptable, as it demonstrates a failure to proactively manage regulatory risk, potentially leading to unexpected and substantial financial penalties or the inability to legally operate their vehicle. Another incorrect approach would be to make a decision based solely on anecdotal evidence or the opinions of other drivers, without performing any independent financial assessment. This lacks the rigor required for sound financial decision-making and exposes the driver to significant unquantified risk. A further incorrect approach would be to invest in a new vehicle without a clear understanding of the total cost of ownership under the new regulations, potentially overspending or choosing a vehicle that will also face future compliance issues. Professionals should employ a structured decision-making process that begins with identifying all relevant regulatory changes and their potential impacts. This should be followed by a thorough quantitative analysis of the financial implications, considering various scenarios and probabilities. Finally, a decision should be made based on this data, prioritizing compliance and financial prudence. Question 11. Implementation of new, more stringent Know Your Client (KIC) procedures in Ontario, Canada is mandated by regulatory updates. A financial advisory firm is considering how to best integrate these changes into their client onboarding process. Which of the following approaches would be considered the most professionally sound and compliant with Ontario's regulatory framework? Option A. Implement the enhanced KYC procedures for all clients, but without providing specific training to staff on the new requirements and their rationale. Option B. Immediately implement the enhanced KYC procedures for all new and existing clients without prior testing or staff training. Option C. Conduct a pilot program with a subset of new clients to test the enhanced KYC procedures, gather feedback, and refine the process before a full firm-wide rollout. Option D. Implement the enhanced KYC procedures only for new clients, deferring their application to existing clients until a later, unspecified date. The correct answer is C. Conduct a pilot program with a subset of new clients to test the enhanced KYC procedures, gather feedback, and refine the process before a full firm-wide rollout. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, regarding the implementation of a new client onboarding process that incorporates enhanced Know Your Client (KIC) procedures. The challenge lies in balancing the need for thorough due diligence, as mandated by regulatory bodies like the Ontario Securities Commission, OSC, and FINTRAC, with the practicalities of client experience and operational efficiency. Failing to adequately implement these new procedures could expose the firm and the advisor to significant regulatory penalties, reputational damage, and potential harm to clients. Conversely, an overly burdensome process could deter new clients or frustrate existing ones. Careful judgment is required to ensure compliance without compromising business objectives or client relationships. Correct approach analysis. The best approach involves a phased rollout of the enhanced KYC procedures, beginning with a pilot program involving a select group of new clients. This approach is correct because it allows the firm to test the new procedures in a controlled environment, identify any practical issues or bottlenecks, and gather feedback before a full-scale implementation. This aligns with the principles of responsible implementation and risk management, ensuring that the firm can adapt and refine the process to be both compliant and client-friendly. Specifically, this proactive testing and refinement directly supports the OSC's mandate for robust investor protection and FINTRAC requirements for effective anti-money laundering (AML) and counter-terrorist financing (CTF) measures by ensuring the procedures are practical and effective in practice. Incorrect approach is analysis. Implementing the enhanced KYC procedures immediately and without any prior testing or training for staff is professionally unacceptable. This approach risks overwhelming staff, leading to errors in data collection and client identification, which would be a direct contravention of FinTrack requirements for accurate client identification and record keeping. It also fails to consider the client experience, potentially leading to frustration and a negative perception of the firm, which indirectly undermines the OSC's focus on fair treatment of investors. Implementing the enhanced KYC procedures only for existing clients while deferring their application to new clients is also professionally unacceptable. This creates an inconsistent application of regulatory requirements, potentially leaving the firm vulnerable to noncompliance for a significant portion of its client base. It also fails to address the core purpose of enhanced KYC, which is to mitigate risks associated with all client relationships, both new and existing, as required by both OSC and FinTrack guidelines. Implementing the enhanced KYC procedures without providing adequate training to staff on the new requirements and the rationale behind them is professionally unacceptable. This approach is likely to result in inconsistent application of the procedures, misunderstandings, and potential breaches of privacy or data security protocols. It directly contravenes the spirit of regulatory guidance that emphasizes the importance of knowledgeable and competent staff in maintaining compliance and protecting client interests. Professional reasoning. Professionals should adopt a structured and iterative approach to implementing new regulatory requirements. This involves understanding the specific obligations, assessing the impact on operations and clients, developing a clear implementation plan that includes pilot testing and training, and establishing mechanisms for ongoing monitoring and refinement. A risk-based approach, prioritizing areas of highest regulatory concern and client impact, is crucial. Furthermore, open communication with staff and clients throughout the implementation process is essential for fostering understanding and cooperation. Question 12. To address the challenge of ensuring a new driver in Ontario, Canada, can safely and legally operate a vehicle, what is the most effective pedagogical approach for a driving instructor? Option A. A curriculum that integrates theoretical instruction on the Ontario Highway Traffic Act with practical, supervised driving experience in diverse Ontario road conditions, emphasizing the reasoning behind rules and their real-world application. Option B. A generalized driving instruction program that covers common driving principles but does not specifically address Ontario's unique traffic laws or environmental factors. Option C. An approach that prioritizes rapid progression through the curriculum to get the driver to their road test as quickly as possible, even if practical understanding is superficial. Option D. A method that focuses primarily on memorizing the Ontario Highway Traffic Act, with minimal emphasis on practical driving scenarios. The correct answer is A. A curriculum that integrates theoretical instruction on the Ontario Highway Traffic Act with practical, supervised driving experience in diverse Ontario road conditions, emphasizing the reasoning behind rules and their real-world application. Explanation. To address the challenge of ensuring a new driver's understanding of the specific road rules and safe driving practices applicable in Ontario, Canada, a driving instructor must implement a training program that goes beyond rote memorization of the Ontario Highway Traffic Act. The professional challenge lies in translating legal requirements into practical, safe driving behaviors and adapting instruction to the individual learner's needs and the unique driving environment of Ontario, which includes varying weather conditions, diverse road types, urban, rural, highway, and specific traffic patterns. The best approach involves a structured curriculum that integrates theoretical knowledge of the Ontario Highway Traffic Act with practical, hands-on application. This includes demonstrating and practicing maneuvers in various Ontario settings, discussing the rationale behind specific rules, e.g., why certain speed limits are posted in school zones, and providing feedback that connects observed behavior directly to Ontario's legal requirements and safe driving principles. This method ensures the driver not only knows the rules but understands their purpose and can apply them consistently and safely in real-world Ontario driving scenarios. This aligns with the Ministry of Transportation Ontario's MTO mandate for driver education to produce safe and responsible drivers. An incorrect approach would be to solely focus on memorizing the Ontario Highway Traffic Act without practical application. This fails to equip the driver with the judgment and skills needed to navigate complex or unexpected situations, potentially leading to unsafe driving and violations, even if the driver can recite the law. Another incorrect approach is to rely on generic driving advice that is not tailored to Ontario's specific regulations or driving conditions. This could lead to the driver being unaware of or misapplying Ontario-specific rules, such as those pertaining to winter driving or specific municipal bylaws, thereby compromising safety and legal compliance. Finally, an approach that prioritizes speed of learning over thorough understanding and skill development, pushing the driver towards the test without ensuring genuine competency, is also professionally unacceptable. This neglects the ethical responsibility to ensure the driver is truly prepared for the responsibilities of operating a vehicle on Ontario roads. Professionals should employ a decision-making process that prioritizes learner comprehension and safety above all else. This involves understanding the specific regulatory requirements of Ontario, assessing the individual learner's progress and identifying areas needing more attention, designing and delivering instruction that bridges theoretical knowledge with practical application, and continuously evaluating the learner's ability to drive safely and legally in the context of Ontario's driving environment. Question 13. Examination of the data shows that an investment advisor in Ontario, Canada, is recommending a specific mutual fund to a client. The advisor has a close personal friendship with the CEO of the fund management company. What is the most appropriate course of action for the advisor to take? Option A. Proceed with the recommendation and assume the client will not be negatively impacted by the advisor's personal connection. Option B. Inform the client about the personal relationship with the CEO of the fund management company before proceeding with the recommendation. Option C. Recommend the fund and disclose the personal relationship only after the client has made the investment. Option D. Advise the client that they might figure out the advisor's connection to the fund company later. The correct answer is B. Inform the client about the personal relationship with the CEO of the fund management company before proceeding with the recommendation. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, regarding the disclosure of a potential conflict of interest. The advisor has a personal relationship with a company whose investment products they are recommending. Navigating this situation requires careful judgment to ensure client interests are prioritized above personal gain and to maintain compliance with regulatory obligations. The challenge lies in balancing the advisor's professional duty with their personal connection, ensuring transparency and avoiding any perception of undue influence. Correct approach analysis. The best professional practice involves proactively disclosing the personal relationship to the client before any recommendation is finalized. This approach aligns with the principles of client centricity and transparency mandated by regulatory bodies in Ontario, such as the Financial Services Regulatory Authority of Ontario, FSRA. Full disclosure allows the client to make an informed decision, understanding any potential biases that might exist. This upholds the advisor's fiduciary duty to act in the client's best interest and fosters trust. Incorrect approach is analysis. Recommending the product without mentioning the personal relationship is a direct violation of disclosure requirements. It creates a hidden conflict of interest, potentially misleading the client and breaching their trust. Failing to disclose is unethical and can lead to disciplinary action, including fines and license suspension, under FSRA regulations. Suggesting the client might figure it out, or downplaying the relationship, implies an attempt to circumvent disclosure obligations, which is unprofessional and ethically unsound. It demonstrates a lack of commitment to transparency and client well-being. Waiting until after the client has invested to disclose the relationship is also unacceptable. Disclosure must be proactive and precede the client's decision-making process. This delayed disclosure deprives the client of crucial information at the point of decision and still constitutes a failure to manage the conflict of interest appropriately. Professional reasoning. Professionals should adopt a framework that prioritizes transparency and client interests. This involves identifying potential conflicts of interest early, assessing their impact on client recommendations, and implementing clear disclosure protocols. When in doubt, erring on the side of overdisclosure is always the safer and more ethical path. Regulatory guidelines in Ontario emphasize the importance of acting with integrity and in the best interest of the client, which necessitates open communication about any factors that could influence advice. Question 14. Research into a colleague's client file in Ontario, Canada, has revealed a potential discrepancy where the client's stated investment objectives appear to have been misrepresented to facilitate a particular product sale. What is the most appropriate and ethically sound course of action for the advisor who discovered this discrepancy? Option A. Immediately report the observed discrepancy to the firm's internal compliance department or designated supervisor for investigation and appropriate action. Option B. Discreetly advise the colleague to correct the client's file without involving any formal reporting channels, assuming the colleague will comply. Option C. Overlook the discrepancy, assuming the colleague has a valid reason or will address it independently at a later time. Option D. Confront the colleague directly and demand an immediate explanation and correction of the client's file. The correct answer is A. Immediately report the observed discrepancy to the firm's internal compliance department or designated supervisor for investigation and appropriate action. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, who has discovered a potential misrepresentation by a colleague regarding a client's investment objectives. The challenge lies in balancing the duty of client care and regulatory compliance with collegial relationships and the potential for internal conflict. Careful judgment is required to ensure client interests are protected without causing undue harm to colleagues or the firm, while strictly adhering to Ontario's regulatory framework for financial advisors. Correct approach analysis. The best professional practice involves immediately and discreetly reporting the observed discrepancy to the appropriate internal compliance department or supervisor. This approach is correct because it directly addresses the potential breach of regulatory requirements and ethical duties. Under Ontario's regulatory framework, specifically the mandate of the Financial Services Regulatory Authority of Ontario, FSRA, advisors have a fundamental obligation to act in the best interests of their clients. This includes ensuring that client investment objectives are accurately documented and reflected in their investment strategies. By reporting the issue internally, the advisor initiates a formal review process that can lead to the correction of the misrepresentation, safeguarding the client's financial well-being and upholding the integrity of the advisory process. This aligns with the principles of client centricity and regulatory adherence expected of all licensed individuals in Ontario. Incorrect approaches analysis. Failing to report the discrepancy and instead attempting to coach the colleague on how to correct the client's file without involving compliance is professionally unacceptable. This approach circumvents the established regulatory reporting mechanisms and could lead to the misrepresentation being overlooked or inadequately addressed. It also places the advisor in a position of potentially complicity if the issue is later discovered, and it fails to uphold the advisor's direct responsibility to ensure regulatory compliance. Ignoring the discrepancy entirely and assuming the colleague will rectify it is also professionally unacceptable. This passive approach neglects the advisor's duty of care to the client and their obligation to report potential regulatory breaches. It prioritizes avoiding conflict over client protection and regulatory integrity, which is a direct violation of professional standards in Ontario. Directly confronting the colleague in a manner that could be perceived as accusatory or threatening, without first involving the compliance department, is professionally risky. While direct communication can be valuable, in this context, it bypasses the structured and confidential reporting channels designed to handle such sensitive matters. This could lead to defensiveness, denial, and an escalation of conflict, potentially hindering a proper investigation and resolution, and failing to meet the advisor's obligation to report suspected misconduct through appropriate channels. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes regulatory compliance and client best interests. When a potential breach is identified, the first step should always be to consult the firm's internal policies and procedures for reporting such matters. If these are unclear or absent, the advisor should err on the side of caution and report the concern through the most direct and appropriate internal channel, such as a compliance officer or supervisor. This ensures that the issue is handled formally, investigated thoroughly, and addressed in accordance with regulatory requirements, thereby protecting both the client and the integrity of the financial services industry in Ontario. Question 15. Which approach would be most appropriate for a driving instructor in Ontario, Canada, when a student expresses confidence in their ability to pass the G2 road test, but the instructor has observed consistent errors in critical areas such as lane changes and intersection observation during practice sessions? Option A. Conduct a thorough mock road test simulating the official MTO G2 examination. Provide detailed feedback on observed deficiencies, and advise the student to postpone the test until proficiency in all required areas is demonstrated. Option B. Inform the student that they are not ready and refuse to provide any further instruction or assistance with the road test, without offering specific guidance on how to improve. Option C. Proceed with booking the G2 road test as requested by the student, focusing practice sessions on familiarizing the student with common test routes and tips for passing. Option D. Encourage the student to take the test and assure them that minor errors are often overlooked by examiners, emphasizing their overall confidence in the student's ability. The correct answer is A. Conduct a thorough mock road test simulating the official MTO G2 examination, provide detailed feedback on observed deficiencies, and advise the student to postpone the test until proficiency in all required areas is demonstrated. Explanation. Scenario analysis. This scenario presents a challenge for a driving instructor in Ontario, Canada, who is tasked with preparing a student for the G2 road test. The challenge lies in balancing the student's perceived readiness with the objective requirements of the Ontario Ministry of Transportation, MTO, testing standards, and the instructor's ethical obligation to ensure public safety. The instructor must avoid personal bias or pressure from the student to rush the process, which could lead to a failed test or, more critically, an unsafe driver on Ontario roads. Correct approach analysis. The best professional approach involves a thorough, objective assessment of the student's driving skills against the official MTO G2 road test criteria. This means conducting a mock test that mirrors the actual examination, covering all required maneuvers and decision-making scenarios. The instructor should provide constructive feedback, identifying specific areas where the student falls short of the MTO standards. If the student does not meet these standards, the instructor must ethically advise against proceeding with the test, explaining that further practice is necessary to ensure safety and a higher likelihood of passing. This aligns with the MTO's mandate to license competent and safe drivers and upholds the instructor's professional responsibility to their student and the public. Incorrect approach is analysis. One incorrect approach is to proceed with the road test simply because the student feels ready or has expressed a strong desire to take it, despite the instructor's reservations. This disregards the MTO's established testing standards and prioritizes the student's immediate desire over their actual preparedness and public safety. It is an abdication of the instructor's professional duty to assess competence objectively. Another incorrect approach is to focus solely on teaching the tricks or specific routes that might be common on the test, rather than on developing fundamental driving skills and hazard perception. While familiarity with test procedures is helpful, a true understanding of safe driving principles is paramount. This approach risks producing a driver who can pass the test but may not be truly safe in varied real-world driving conditions. A third incorrect approach is to become overly critical and discouraging, leading to a loss of student confidence. While honesty is crucial, the feedback should be constructive and aimed at improvement, not demoralization. However, this is less of a regulatory failure and more of a pedagogical one, though it can indirectly impact the student's ability to learn and perform. The primary regulatory and ethical failure in this context is proceeding with a test when the student demonstrably does not meet the required safety and skill standards. Professional reasoning. Professionals in this field should employ a decision-making framework that prioritizes safety and adherence to regulatory standards. This involves 1. Understanding and internalizing the specific requirements of the licensing body, MTO in this case. 2. Conducting objective, skills-based assessments that directly correlate with these requirements. 3. Communicating assessment results clearly and constructively to the client. 4. Making recommendations based on objective data and regulatory compliance, even if it means delaying a desired outcome for the client. 5. Maintaining professional integrity by refusing to compromise standards for convenience or external pressure. Question 16. Benchmark analysis indicates that financial advisors in Ontario, Canada, often face situations where clients express a strong desire for high-return investments, even if those investments carry significant risks. Considering the regulatory framework in Ontario and EROC guidelines, what is the most appropriate course of action for an advisor when a client, who has previously indicated a moderate risk tolerance, now requests to invest a substantial portion of their portfolio in a liquid, high-risk private equity fund, citing a recent article about its potential returns? Option A. Inform the client that their request is inconsistent with their previously stated moderate risk tolerance and decline to proceed with the investment without further discussion or exploration of alternative options. Option B. Proceed with the investment as requested, assuming the client's stated desire for high returns overrides their previous risk tolerance, and rely on the client's assurance that they understand the risks involved. Option C. Conduct a detailed suitability assessment that reevaluates the client's overall financial situation, investment objectives, and capacity for loss, and thoroughly research the private equity fund's risks and liquidity before providing a recommendation, ensuring comprehensive disclosure of all material facts and potential conflicts. Option D. Recommend the investment based on the client's current expressed interest, but advise them that it is a high-risk investment and they should be prepared for potential losses, without conducting further in-depth suitability analysis or fund due diligence. The correct answer is C. Conduct a detailed suitability assessment that reevaluates the client's overall financial situation, investment objectives, and capacity for loss, and thoroughly research the private equity fund's risks and liquidity before providing a recommendation, ensuring comprehensive disclosure of all material facts and potential conflicts. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, who is tasked with advising a client on a significant investment decision. The challenge lies in balancing the client's stated risk tolerance with the inherent risks of a complex, illiquid investment, while adhering to regulatory obligations. The advisor must navigate potential conflicts of interest, ensure adequate disclosure, and act in the client's best interest, all within the framework of Ontario securities law and the Investment Industry Regulatory Organization of Canada, EROC. Rules. Correct approach analysis. The best professional practice involves a thorough, documented assessment of the client's financial situation, investment objectives, and risk tolerance, going beyond the client's initial statements. This includes understanding the client's knowledge of complex investments and their capacity to absorb potential losses. The advisor must then conduct due diligence on the proposed investment, ensuring they fully understand its risks, liquidity, and suitability for the client. Crucially, the advisor must provide clear, comprehensive disclosure of all material facts, including any potential conflicts of interest, and obtain informed consent. This approach aligns with the fiduciary duty owed to clients under Ontario securities law and EROC client-focused conduct rules, which mandate suitability assessments and acting with integrity. Incorrect approach is analysis. Recommending the investment solely based on the client's stated desire for high returns, without a deeper suitability assessment, fails to meet the advisor's regulatory obligations. This approach risks misrepresenting the client's true risk profile and could lead to an unsuitable investment recommendation, violating suitability rules. Proceeding with the investment after a superficial review of the offering memorandum, assuming the client's stated risk tolerance is sufficient, ignores the advisor's duty to conduct independent due diligence and understand the investment's complexities. This can lead to a failure to identify and disclose all material risks. Accepting the client's assurance that they understand the risks without independent verification and detailed disclosure is also problematic. While client understanding is important, the advisor has a responsibility to ensure that understanding is informed and complete, especially for illiquid and complex products. Professional reasoning. Professionals should employ a structured decision-making process that prioritizes client well-being and regulatory compliance. This involves 1. Comprehensive client discovery, moving beyond surface-level information to a deep understanding of the client's financial situation, objectives, and true risk capacity. 2. Independent due diligence, thoroughly researching and understanding any proposed investment, its risks, and its alignment with the client's profile. 3. Transparent disclosure, providing all material information including risks and conflicts in a clear and understandable manner. 4. Informed consent, ensuring the client genuinely understands and agrees to the investment based on complete information. 5. Documentation, maintaining detailed records of all assessments, discussions, and decisions. Question 17. Benchmark analysis indicates that a financial advisor in Ontario, Canada, is considering recommending an investment fund to a client. The firm offers a proprietary fund that generates higher commissions for the firm and the advisor compared to other available funds. The client has expressed a desire for moderate growth and capital preservation. What is the most appropriate course of action for the advisor? Option A. Recommend the proprietary fund because it is offered by the firm and aligns with the firm's product strategy, assuming it meets the client's general investment objectives. Option B. Conduct a comprehensive analysis of the client's financial situation and investment objectives. Explore a range of suitable investment options including non-proprietary funds, and recommend the fund that best aligns with the client's needs, while transparently disclosing any potential conflicts of interest related to proprietary products. Option C. Suggest the proprietary fund to the client, highlighting its features, without extensively researching or presenting alternative investment options, as the firm's products are generally considered competitive. Option D. Prioritize recommending the proprietary fund due to the higher commission structure, as this benefits both the advisor and the firm, and is a standard practice in the industry. Correct answer is B. Conduct a comprehensive analysis of the client's financial situation and investment objectives. Explore a range of suitable investment options including non-proprietary funds, and recommend the fund that best aligns with the client's needs, while transparently disclosing any potential conflicts of interest related to proprietary products. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, due to the inherent conflict of interest when recommending a proprietary product. The advisor must navigate the regulatory requirements of the Ontario Securities Commission, OSC, and the ethical obligations to act in the client's best interest, ensuring transparency and avoiding undue influence. The challenge lies in balancing the firm's product offerings with the client's specific needs and financial circumstances, demanding careful judgment to uphold fiduciary duties. Correct approach analysis. The best professional practice involves a thorough, unbiased assessment of the client's financial situation and investment objectives, followed by a recommendation that prioritizes the client's best interests above all else. This approach necessitates exploring a range of suitable investment options, including those outside the firm's proprietary offerings, and clearly disclosing any potential conflicts of interest, such as the firm's ownership of the recommended fund. This aligns with OSC regulations requiring advisors to act with integrity and diligence, and to place client interests first, as well as the ethical principles of transparency and avoiding conflicts of interest. Incorrect approach is analysis. Recommending the proprietary fund solely because it is offered by the firm, without a comprehensive comparison to other suitable investments, violates the duty to act in the client's best interest and may breach OSC regulations regarding suitability and conflict of interest disclosure. Prioritizing the firm's product due to higher commission potential, without demonstrating that it is the most appropriate choice for the client, is an unethical and potentially illegal practice. Suggesting the proprietary fund without fully understanding the client's risk tolerance and financial goals, and without exploring alternatives, fails to meet the standard of care expected of a financial advisor in Ontario. Professional reasoning. Professionals should adopt a client-centric decision-making framework. This involves 1. Understanding the client's needs, objectives, and risk profile thoroughly. 2. Identifying all suitable investment options that meet these criteria, regardless of the firm's product shelf. 3. Conducting a rigorous comparative analysis of these options. 4. Transparently disclosing any potential conflicts of interest related to recommended products. 5. Making a recommendation based solely on the client's best interests, supported by clear rationale. Question 18. Benchmark analysis indicates that financial advisors in Ontario, Canada, often face challenges in aligning client-stated investment objectives with their actual risk tolerance. Considering the regulatory framework in Ontario, which approach best addresses the implementation challenge of recommending an investment strategy for a client who verbally expresses a desire for aggressive growth, but has a history of selling investments during market downturns? Option A. Recommend a conservative portfolio that prioritizes capital preservation, as the client's past actions suggest a low tolerance for risk, even if it contradicts their stated desire for aggressive growth. Option B. Conduct a detailed review of the client's investment history to identify patterns of behavior during market fluctuations. Engage in a candid discussion about their emotional responses to risk, and clearly explain how different investment strategies might impact their portfolio, ensuring the client understands the potential for both gains and losses. Option C. Present a diversified portfolio with a significant allocation to aggressive growth assets, assuming the client's verbal assertion overrides any past behavior, and focus on the potential upside of the investments. Option D. Proceed with recommending an aggressive growth portfolio, as the client has explicitly stated their desire for high returns, and document this stated preference as the primary driver for the recommendation. The correct answer is B. Conduct a detailed review of the client's investment history to identify patterns of behavior during market fluctuations. Engage in a candid discussion about their emotional responses to risk, and clearly explain how different investment strategies might impact their portfolio, ensuring the client understands the potential for both gains and losses. Explanation. Scenario analysis. This scenario presents a professional challenge for a financial advisor in Ontario, Canada, due to the inherent conflict between a client's stated desire for aggressive growth and their demonstrated risk aversion in previous investment decisions. The advisor must navigate this discrepancy while adhering to regulatory obligations concerning suitability and client understanding. The challenge lies in ensuring that the recommended investment strategy is not only aligned with the client's stated goals, but also genuinely suitable given their past behavior and capacity for risk, thereby preventing potential future complaints or regulatory scrutiny. Correct approach analysis. The best professional practice involves a multifaceted approach that prioritizes a thorough understanding of the client's true risk tolerance. This includes a detailed review of the client's investment history, specifically examining past reactions to market volatility and any instances of selling investments during downturns. It also necessitates a candid discussion with the client about their emotional responses to risk and a clear explanation of how different investment strategies might impact their portfolio during various market conditions. This approach aligns with the Ontario Securities Commission (OSC) Rule 31-505 registration requirements, specifically the sections pertaining to Know Your Client (KIC) obligations and suitability assessments. By actively seeking to reconcile stated goals with demonstrated behavior and ensuring client comprehension, the advisor fulfills their fiduciary duty and regulatory requirements to act in the client's best interest. Incorrect approach is analysis. Recommending an aggressive growth portfolio solely based on the client's verbal assertion of wanting high returns, without further investigation into their risk tolerance and past behavior, fails to meet the KYC and suitability obligations under OSC Rule 31-505. This approach ignores crucial behavioral indicators of risk aversion and could lead to an unsuitable recommendation. Another incorrect approach involves presenting a highly diversified portfolio with a significant allocation to aggressive growth assets, but without adequately explaining the potential for substantial losses and the client's likely emotional reaction to such volatility. This constitutes a failure to ensure the client fully understands the risks involved, which is a key component of suitability. Finally, suggesting a conservative portfolio despite the client's stated desire for aggressive growth, without a clear and documented explanation of why this is deemed more suitable based on their risk profile and past behavior, could lead to client dissatisfaction and a perception of the advisor not acting in accordance with their stated objectives, even if it is ultimately more suitable from a risk perspective. The advisor must always strive to bridge the gap between stated desires and actual suitability through communication and evidence. Professional reasoning. Professionals should employ a structured decision-making process that begins with a comprehensive Know Your Client process, extending beyond stated preferences to include behavioral analysis and risk assessment. This should be followed by a thorough suitability assessment that considers the client's financial situation, investment objectives, and risk tolerance. Crucially, open and transparent communication is paramount, ensuring the client understands the rationale behind any recommendation and the associated risks. Any discrepancies between stated goals and demonstrated behavior must be explored and addressed directly. Documentation of all discussions, assessments, and recommendations is essential for accountability and regulatory compliance. Question 19. The efficiency study reveals a significant backlog in processing new driver license applications at the Ontario Ministry of Transportation, MTO. What is the most professionally responsible approach to address this backlog while ensuring compliance with the Ontario Highway Traffic Act? Option A. Prioritize speed over accuracy by accepting incomplete documentation and relying on self-certification without adequate checks. Option B. Outsource application processing to third-party vendors with minimal oversight to increase throughput. Option C. Implement targeted process improvements, optimize staff allocation, and explore temporary staffing solutions, ensuring all verification steps mandated by the Highway Traffic Act are maintained. Option D. Expedite processing by reducing the number of verification steps for all new applications to clear the backlog quickly. Correct answer is C. Implement targeted process improvements, optimize staff allocation, and explore temporary staffing solutions, ensuring all verification steps mandated by the Highway Traffic Act are maintained. Explanation. The efficiency study reveals a significant backlog in processing new driver license applications at the Ontario Ministry of Transportation, MTO. This backlog is impacting the ability of new drivers to legally operate vehicles, potentially leading to unlicensed driving and related safety concerns. The challenge lies in balancing the need for efficiency with the MTO's statutory obligations under the Ontario Highway Traffic Act and its associated regulations, which mandate specific procedures and timelines for application processing and the issuance of licenses. The MTO must ensure that all applications are reviewed thoroughly to confirm eligibility and compliance with provincial requirements, while also addressing the operational bottleneck. The best approach involves a multifaceted strategy that prioritizes addressing the root causes of the backlog without compromising the integrity of the licensing process or the safety of the public. This includes implementing targeted process improvements, such as digitizing paper-based workflows where feasible and appropriate, optimizing staff allocation based on application volume, and potentially exploring temporary staffing solutions during peak periods. Crucially, any changes must be vetted to ensure they align with the MTO's legal mandate to verify applicant identity, residency, and driving knowledge and skill, as outlined in the Highway Traffic Act. This approach upholds the MTO's duty to issue licenses only to qualified individuals, thereby protecting public safety and maintaining the credibility of the licensing system. An approach that focuses solely on expediting processing by reducing the number of verification steps would be professionally unacceptable. This would directly contravene the MTO's statutory duty to ensure applicants meet all eligibility criteria before a license is issued, potentially leading to unqualified individuals obtaining licenses and increasing road safety risks. Similarly, an approach that involves outsourcing application processing to third-party vendors without rigorous oversight and adherence to MTO's established standards would be problematic. This could lead to inconsistent application of regulations, data security breaches, and a dilution of accountability, all of which are contrary to the MTO's responsibilities under provincial law. Furthermore, an approach that prioritizes speed over accuracy by accepting incomplete documentation or relying on self-certification without adequate checks would undermine the integrity of the licensing system and violate the principles of due diligence mandated by the Highway Traffic Act. Professionals facing such implementation challenges should adopt a structured decision-making process. This involves clearly identifying the problem and its impact, thoroughly understanding the relevant legal and regulatory framework, in this case, the Ontario Highway Traffic Act and MTO policies, brainstorming potential solutions, and then critically evaluating each solution against legal compliance, operational feasibility, public safety implications, and ethical considerations. Prioritizing solutions that enhance efficiency while rigorously maintaining statutory compliance and public safety is paramount. Question 20. Benchmark analysis indicates that a client in Ontario experiencing unexpected personal expenses urgently requests the liquidation of a significant portion of their investment portfolio to cover immediate needs. The portfolio includes a mix of equities and fixed-income securities. The client is visibly distressed and emphasizes the need for immediate access to funds. Considering the Ontario Securities Commission (OSC) regulations and the advisor's fiduciary duty, what is the most appropriate course of action for the financial advisor? Option A. Immediately proceed with the liquidation of the requested assets to meet the client's urgent demand, as the client's instructions are paramount. Option B. Conduct a comprehensive review of the client's current financial situation, risk tolerance, and long-term objectives. Explore alternative solutions to mitigate immediate financial pressure without jeopardizing long-term goals, and clearly explain the potential consequences of liquidation, including tax implications and market timing risks. Option C. Recommend liquidating only the most volatile assets to minimize potential losses, without a full review of the client's overall financial situation or long-term goals. Option D. Advise the client that their emotional state is not a factor in financial decision-making and proceed with the liquidation as requested, focusing solely on the transaction mechanics. The correct answer is B. Conduct a comprehensive review of the client's current financial situation, risk tolerance, and long-term objectives. Explore alternative solutions to mitigate immediate financial pressure without jeopardizing long-term goals, and clearly explain the potential consequences of liquidation, including tax implications and market timing risks. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's immediate financial needs and the long-term implications of their investment decisions, particularly when those decisions might be influenced by emotional distress. The advisor must navigate the client's urgent request while upholding their fiduciary duty to act in the client's best interest, which includes providing sound, objective advice that considers risk tolerance and financial goals. Pressure to act quickly, coupled with the potential for significant financial loss if the advice is poor, demands careful judgment and adherence to regulatory standards. Correct approach analysis. The best professional practice involves a thorough assessment of the client's current financial situation, risk tolerance, and long-term objectives before recommending any course of action. This includes understanding the specific reasons behind the client's desire to liquidate assets, exploring alternative solutions that might mitigate immediate financial pressure without jeopardizing long-term goals, and clearly explaining the potential consequences of liquidation, including tax implications and market timing risks. This approach aligns with the principles of responsible financial advice, emphasizing client well-being and informed decision-making, as mandated by the Ontario Securities Commission (OSC) regulations, which require advisors to act with integrity and in the best interest of their clients. Incorrect approaches analysis. Recommending immediate liquidation without a comprehensive review of the client's overall financial picture and risk profile is professionally unacceptable. This approach fails to consider the client's long-term financial health and could lead to significant losses due to poor market timing or the realization of capital gains taxes. It also bypasses the advisor's duty to educate the client on the full implications of their decision. Another unacceptable approach is to proceed with the liquidation solely based on the client's stated urgency without probing deeper into the underlying reasons or exploring less drastic alternatives. This demonstrates a lack of due diligence and a failure to fulfill the advisor's responsibility to provide comprehensive guidance. Finally, suggesting that the client's emotional state is irrelevant and proceeding with the transaction without acknowledging or addressing the potential impact of their distress on their judgment is also a significant ethical and professional failing. Advisors have a responsibility to ensure clients are making decisions with a clear mind, especially when significant financial actions are involved. Professional reasoning. Professionals should adopt a structured decision-making process that prioritizes client welfare and regulatory compliance. This involves 1. Active listening and empathy. Understand the client's situation and emotional state. 2. Information gathering. Collect all relevant financial data and understand the client's goals and risk tolerance. 3. Risk assessment. Analyze the potential consequences of various actions. 4. Solution exploration. Identify and present a range of suitable options, including alternatives to the client's initial request. 5. Clear communication. Explain all options, risks, and benefits in an understandable manner. 6. Documentation. Record all advice given and decisions made. This systematic approach ensures that advice is not only compliant but also ethically sound and tailored to the client's unique circumstances, as expected under OSC guidelines.